it's my great pleasure to welcome Andrew Ferguson, Chairman of the Federal Trade Commission. Chair Ferguson most recently served as Solicitor General of the Commonwealth of Virginia, and prior to that position, he served as Chief Counsel to the United States Senator Mitch McConnell of Kentucky, the Republican leader, and as a Republican counsel on the United States Senate Judiciary Committee. Leading the discussion with the chairman will be our Chief Science Officer, Dr. Dimitri Christakis. Dimitri and Chairman Ferguson, the stage is yours.
Chairman Ferguson, thank you so much for coming. Now, should I call you Chairman Ferguson?
Andrew's fine.
Okay. I want you to call me Dr. Christakis. No. No, Dimitri. It's really a pleasure to have you here. I appreciate your taking time out of your busy day, busy life. Let me start by asking a question for a friend. What exactly is the FTC, and what does it actually do historically, and then what is your vision for it? I know, of course, but a lot of the people out here don't.
Well, I'm happy to fill in all of the people in the audience, since you're good. The FTC is the Federal Trade Commission. It's an agency of the executive branch of the federal government that was adopted pursuant to a law passed in 1914. It came to existence in 1915. Its original mandate was to enforce the antitrust laws. So most of you are probably at least very generally familiar with the antitrust laws. They're the laws governing merger policy in the United States, and then they are the laws that forbid companies from, for example, getting into a back room behind all your backs, agreeing to fix prices so that you guys have to pay more than you would if they were competing with each other. So our antitrust laws are the laws that keep our markets free because they make sure people are competing for your money. And then in 1935, Congress added a provision to the Federal Trade Commission Act that forbids unfair and deceptive acts and practices. And we sort of colloquially call that our Consumer Protection Authority as compared to our antitrust or our competition authority. And unfair and deceptive acts and practices sounds pretty broad. It is pretty broad. A very famous judge in New York once said in the 1980s when he was adjudicating an FTC case, unfairness can be a bit in the eye of the beholder, which is true. Deception, a little sort of clearer, it harkens to common law ideas of fraud. Very straightforward. We have a very ancient prohibition against tricking someone into turning over their money to you, and that's the anti-deception principle. And unfairness, a lot broader. And over the course of years, Congress has added a bunch of additional sort of specific statutes and given the FTC enforcement authority. I think sort of most relevant to the topic today is the Child Online Privacy Protection Act of 1998, or COPPA. The FTC is the primary enforcer of COPPA. And then within our Unfair and Deceptive Acts and Practices Authority, which you'll hear the nerds in town call UDAP, within our UDAP authority, that is where the FTC has done lots of privacy enforcement and data security enforcement. So the idea that it is unfair for you to onboard people's data but not maintain privacy protection sufficient to keep that data from being absconded with, and then a lot of deception cases where you may represent to a user, we will only do the following 3 things with your data, and then people learn that they do many other things with your data, and since the very early 2000s, the FTC has understood that to be a violation of the prohibition on deception. So the FTC, I think probably more than any other federal enforcer, has done a lot of privacy work, but the United States does not have sort of a standalone general privacy law. A lot of the states now have it, but the federal government, Congress, has not adopted one. And then for children, the sort of classic, or at least for the topic of discussion today, sort of the classic example of the FTC's work is twofold. One, on deception, when you are marketing a product to someone, you generally have to make lots of representations about that product. That's part of how competition works. You put labels on products, you run advertisements on products, you have salesmen make representations about products. The FTC's job is to make sure that whatever consumers are being told is honest. And that is, arguably the FTC's most important work, because if we don't have a system where people in markets, particularly parents when they're buying things for their children, can believe representations being made to them about products and services, the markets will just fall apart. If all of the time you feel like you have to investigate every claim made by everyone in the market, no one has time to do that. The search costs would be catastrophically high. And so making sure that whatever people say about their products is true, for example, if someone sells a porn blocker to parents and they say it'll block, all the porn you can imagine, making sure that representation is true is part of our job. And if it's not, suing them to make sure that they quit making false representations and getting civil penalties under certain circumstances if they've been particularly deceptive. Unfairness is a little trickier. So just because there have been periods in the FTC's history where the FTC has taken exceptionally aggressive views of what qualifies as an unfair practice, Congress has tended to rebuke the FTC when it goes too far. In the late 90s, Congress passed a law that added some definitional structures to unfairness to try to constrain FTC decision-making a little bit. But just there's a very general overview of what the FTC does and how it relates to the topics that you all have come to talk about today.
And in light of that, I mean, many of us some of us participated in the workshop about the intentional economy that the FTC convened, and it caught my attention, frankly, in a very good way. What's the follow-up to that? What do you see more convenings? Do you see taking action? I mean, what you just said right now about false advertising or misrepresentation, do you see that happening now with social media companies in a way that the FTC could act on?
So let me qualify what I'm about to say because we're a law enforcement agency, we bring lawsuits, we get injunctions, we get civil penalties, sometimes for billions of dollars. There's a statute that pretty tightly circumscribes specific things I can say about our enforcement work. What I can say, following on from the Attention Economy Workshop, first, I don't know how many people here participated or watched, but it was one of the most successful events the FTC has held in a long time. And it was eye-opening for me. I was the Solicitor General in Virginia, and like most of the states, spend a lot of time dealing with social media companies, dealing with representations that social media companies were making to the citizens of Virginia and trying to figure out if they were true. And that also meant meeting with social media companies and learning, for example, that social media companies hire armies of psychiatrists and pediatricians to help figure out how to build their, not pediatricians.
There's some pediatricians. Yeah, there's some on the dark side, not very many.
But to help structure their products in a way that makes them appealing to children. I'm not a heavy social media user myself. I don't have Instagram, for example. I use Facebook for Facebook Marketplace. I'm an ex-user because if you work in sort of law and government, it's a helpful way to get the news. But I have found myself as a user of social media, even a relatively light user compared to my peers, sometimes just getting caught in the sinkhole as an adult in his 30s. And remember thinking when I was meeting with social media companies and learning that some of the people across the table from me were psychiatrists going, gosh, if you guys can structure this thing to get me to do that, I wonder what you can get it to do to kids. Yes. And so I think part of what the workshop that we held was sort of letting us at the FTC know, like, here is the state of play online. Here are the struggles kids have online. Here are the struggles kids are having in school because of screens. My state, Virginia, my Commonwealth, just passed a no screens in school law, which seemed to be sort of popping up all over the country and seemed like I'm not a scientist and I may be getting out of my skis. Seems like a great idea to me, it was that sort of thing, like learning sort of firsthand from parent advocates, child online safety advocates, scientists. Look, here are sort of the hard effects on kids and uniquely for kids. And I think, my own view generally, and I articulated it in my speech at the beginning of the workshop, is I don't want government to sort of become a secondary parent for kids, even when they're online. I do want government to make it very easy for parents to parent their children online, to set the rules that will govern their children's conduct online. And I want a system that requires the firms that operate in these space to respect the parents' choices. My own view is there are lots of different ways to parent. I don't want the government to articulate the one way that kids should be raised online, but I don't want there to be a system where parents feel utterly helpless in intermediating the relationship of their children with screens and they have nowhere to go. My view is that government is supposed to step into gaps. We're not supposed to order society. Humans order society working collaboratively together, and government fills gaps. And it sure seems after that workshop that the gap is tens of millions of parents who say, I do not like the way that my children operate online, and I don't know what to do about it. Even if I ban screens in my home, they leave my home, they go to friends' houses who may not have that rule, and they go to schools where the screens are everywhere. Every kid's got an iPad in school now. And my view is government ought to step right behind the parent and say, we want you to make the choices for your kids based on what you think is best for your kids and the parenting style you want for your family, and we're going to enforce your choice. How to build that, we're still trying to figure out. Obviously, Congress would have to be the driver here, but that's sort of my overarching view of what needs to happen here is government needs to support parents in intermediating their children and screens.
Well, let's talk a little bit more about that. So the previous panel to this was sort of exploring paths forward. There's people trying to litigate against social media companies to hold them accountable for the harms that they claim have been done to children. And then, of course, there are people that are trying to pass legislation. In your mind, and it's not presumably an either or, which of those do you think is the most appropriate or fruitful paths forward?
So it's not an either or, but it's a really good question. I am a lawyer and litigator by training, and the old saying that to hammer everything is a nail. I want to avoid falling for that trap as a litigator. My main job is to litigate to bring cases under existing laws to protect Americans, and particularly children. But think about the age of the two laws that I just described for you. My main law was passed in 1935. And COPPA was passed in 1998. These are, the 1935 law is a generally applicable law, but it was passed by people who could not have imagined the world in which we now live, could not have imagined the access that children have to, unmediated information all the time coming from the whole planet in an endless stream. It was just sort of, they couldn't have imagined it. And similarly with 1998, COPPA is a great law. It was a huge step forward for Congress, but it's almost 30 years old, and even the markets that they were trying to regulate in 1998 have changed so dramatically. And so, lawyers appropriately see problems, and they want to go to court, and they want to fix them, and it's good, and lawyers perform a valuable service for society when doing that. I say that with no hint of self-interest at all. But modern solutions require modern problems, and I think that if we rely on these generally applicable laws passed many decades ago, we're going to have a square peg round hole problem. It's not going to be a perfect fit, number one. Number two, we are a democracy. We are a self-governing people, and you're going to have far wider agreement and much better uptake of regulations of social media, the internet, children's relationship with those two things, if they are the product of reasoned, often passionate debate and legislation that emerges from that, where everyone gets a say, they can consider all of the evidence. I mean, look, most of you, hopefully none of you are lawyers, but the way that litigation goes is you have a law, and then the evidence that you present to the judge or the jury is governed by whatever the legal claim you're bringing in, which means that there's going to be all sorts of data about the way that the internet and social media affects children that you all would say is relevant to the general question about how to protect children, but because of the way our legal system works, this is not going to be relevant to the suit. But if you are legislating, you can present it all to the elected representatives and say, this is what needs to be done to help children, and then try to convince people. And I think whatever emerges from that is far more likely to address the problems we're having and fix them than hoping for sort of piecemeal litigation. That said, people should litigate when the law is being broken. That is literally my only job, and that should happen, endlessly. But I do not think a healthy society can rely on judges who don't wear robes and lawyers who don't wear robes and lawyers who do wear robes to solve all of society's problems. At some point, the citizens and their legislators have to sit down and figure out, we have this new problem, it requires a new solution, let's figure out what that is.
And federal actions in this respect have been lagging. But we've seen a lot of states pass laws. By the way, red and blue states, in fact, frankly, more red than blue states have passed laws that have been designed to provide protections. But those laws, too, have faced legal challenges and been held up. Where do you see that going?
Yeah, I mean, so I clerked for Justice Thomas. I am an originalist. I'm a legal conservative. And my own view is that the primary locus of policymaking as the Constitution was originally adopted was the states. And the states, Justice Brandeis very famously in his ice cream dissent said the states are the great laboratories of democracy where individual societies can basically experiment with regulation, and if it doesn't work, it doesn't spread to the whole country, and if it does, the rest of the country can take it up. But you can, it's like experimenting in a lab. If it goes badly, only the lab is destroyed. Everybody else can kind of keep going. That was at least the theory. And so I think, as a general matter, state regulation is healthy. It lets us see what works and what doesn't work. And I say that as a former state enforcer. I think Virginia's sort of unique approach to some things is healthy and good. Now, obviously, the issues we are here to talk about today are what the lawyers call interstate commerce, and our Constitution gives Congress the authority to regulate interstate commerce. And then there are some subsidiary doctrines that for a long time were interpreted to say, if it's interstate commerce, even if Congress doesn't act, the states aren't supposed to act. For a long time, there was this weird coalition at the court where Justice Thomas would join with the most liberal justices and say, that's not what the Constitution says. The Constitution says the states can regulate until Congress does. And if that disrupts the national market, that's federalism. That's the laboratories of democracy. It is what it is. And then, because of judicial appointments made in the first Trump administration, there are a lot more justices who agree with that nature of federalism now than did 40 years ago, when sort of the default view of legal conservatism was promote a national market. And I think after the California pork producers case a couple years ago, I think that there is a lot more room for states to legislate on questions that have interstate commerce effects. And look, Virginia passed a law in 2022 that was not dissimilar to the Texas pornography age verification law that the Supreme Court just sustained against a First Amendment challenge. And I can remember when the law was being adopted, its opponents, I was the Solicitor General of Virginia and therefore its chief constitutional defense lawyer. I remember people coming to me and being like, if this is passed, we're going to sue you under the interstate commerce doctrine. And I said, make my day. Like, I would love to have that fight on this issue, protecting kids with this court, like, make my day. So, I think that we are now today with a court that will be probably a lot less hostile to states regulating in the absence of congressional legislation, which was the norm in the country for the first several decades, and then we sort of shifted toward a more national market focus in the late 19th century. There will be challenges. Those challenges are expensive. State budgets state defense budgets are not huge. But I think, I think especially after the Pornhub decision a couple weeks ago, there are some wind in the sails on state legislation on these types of questions.
Let me ask one last question. This is an audience largely of academics and scientists, and what, if any, sort of burning research question do you see that would help the FTC in enforcing, changing, making the internet safer? Where do you see, what are the lacuna, what are the gaps in evidence that are, if that's one of your challenges, and maybe it isn't?
So I think, so definitely yes. And the couple that come to mind are, we as Americans and speakers of English use the word addictive in like two sense. We use it in sort of an informal lay sense, which is like, a product that I really like enjoying, and I'm probably willing to keep enjoying it even at higher cost than I might be willing to enjoy other products. And then addictive in what I understand to be the clinical sense, which is something that alters one's brain chemistry in a way so that a reaction that you would get, you need more and more of it in order to get the chemical reaction. I think trying to understand the effects that, websites, social media platforms, endless access to screens actually has on juvenile brain chemistry would be hugely important. Not just so that we can understand it, we can legislate appropriately, but because that sort of evidence helps us understand whether claims being made about products are true. And that is where the FTC does its best work, is in enforcing the honesty of claims that businesses make about their products. I think every parent, especially today, now that people are starting to understand the effect that social media has on children and young girls in particular, are more closely scrutinizing what companies say about the products that they're offering. And I think that makes it even more important that the FTC has like a base of research to which it can turn to confirm whether representations being made are accurate. Because if they're not, that's where the FTC can do its most important litigation work. And I know that this work is being done, but that is the work that would be sort of on the ground helpful to law enforcers like me.
I want to thank you so much for your time, Chairman Ferguson.